exciting day of IP Masterclass series as part of IP UTSAV 2025, hosted by AICT and Ministry of Education's Innovation Cell. So over the past 2-3 days, we have been diving deep into different forms of intellectual property, exploring copyright, design innovations, and the nuances of patent design, and so on. Now, without further delay, it's my pleasure to introduce our distinguished speaker for today, Dr. Rahul Paneja. He's a scientist at the Directorate of Science and Technology, Government of Haryana. He holds a PhD in pharmaceutical sciences along with advanced degrees in IPR, law, and management. With over 320 expert lectures to his credit, he's a strong advocate of IPR facilitation, drafting, and enforcement, especially among MSMEs and researchers. He's also the recipient of AIMS Award for significant contributions in healthcare. He has also authored 40 plus publications, have multiple IP holdings, and also serves as a brand ambassador for Bentham Science. You may also have seen him on various media platforms promoting IPR awareness. So, on behalf of AICT and Ministry of Education's Innovation Cell, we warmly welcome you, sir. Over
Thank you,
to you,
ma'am.
sir. Dr. Taneja.
Thank you, ma'am, for a wonderful introduction. Thank you for inviting me to share my views on trademark. So there are two types of properties: tangible properties and intangible properties. Tangible properties, like we have one house, we have one vehicle, we have a properties which we can teach and we can feel. We have intangible properties. Intangible properties are different types. Some are scientists, some are painters, some are designers, some are musicians, some are technocrats. We can protect every aspects of the creation of human mind with the different type of IPRs. So there are different types of IPR: patents, trademark, industrial designs, geographical indications, layout designs, trade secrets, and the protection of new plant varieties. These all are covered under into the industrial properties, and another one is the copyright. Copyright is a domain which is yesterday we have discussed in the detail what is the use of the copyrights and what is the benefits of the copyrights. So different types of intangible assets we can protect the different views, and every aspects has their own subject matters. We can't correlate and mix each other with the of EC. Means those things which can be filed by the patent rights, we can't file by the trademarks rights. So every content has their own subject matters. Trademarks. So trademark, why is the trademark is important nowadays? Because suppose if you are doing some new business and you are starting a new enterprises, then trademark plays a very important role. Trademarks is the first point where the entrepreneur can think we can start a new business, that this is our name and we can start by these names. Trademark, a name of the enterprises or mark of capable being representatively, graphically, and distinguish the good or services of one person from another person's. It may be a sign, it may be a words, letter, color of combination, representation, and you can say we can protect any the appearance which can people can identify this product is belong to that company. This can be protected as a trademark. We can protect sign, we can protect words, we can protect color of combination also, we can protect shape of the goods also with the help of the trademark protections. Trademarks are registered by the National Trademark Registry and are valid in that country. So suppose if you are filing a trademark application in India, then your right is limited only to the India. If you want to file a trademark outside the India, then you can file by the two-way. Either you can directly apply to that country through the regional routes, or you can submit by the mandate protocol also. We will discuss mandate protocol in our next slide. The duration of the trademark registration is for the 10 years, but we can renew unlimited time after the 10 years. It's not like a patent. In the patent, you will get a rights only for the 20 years. After 20 years, it will come into the public domains. But in the case of the trademark registration, you will get a rights for the unlimited time, but you have to renew after every 10 years. So this is very important. This is the difference of the trademark. So in which, in generally, we send a trademark is the Ajar and the Amar. We can protect as long as we can use our brand name. So few things cannot be filed for the trademark registration, like state emblems, official marks, and emblems of intergovernmental organization cannot be used as a trademark. Right of the use of TM in relation to good of the services are restricted as a TM when you are applying for the trademark. That is our property and it is protected our name. Trademark and branding is a very important. Most of the time people get confused at what is the difference between trademark or the brand. This is very important line to understand. Every trademark is a brand. but every brand is not a trademark, because most of the time people use their brand name without the protection of the trademark, and they are spending a lot of money. But somehow the similar companies trademarks, which is using similar brand names, are changing the some spelling or the aesthetic feature of the product and selling the goods. So branding is protecting by the help of the trademark protection. Branding is a different and the trademark is a different, because it is a very deep sense to understand the difference between the trademark and the branding. Branding can be strengthened with the help of the trademark protection. Branding allows a company to differentiate its product service from the competitions by creating a bond with this customer. This way, a company can have a position in the market to identify their products and the competition to poach. A satisfied customer may leave, but a loyal customer is made to likely stay with the that brandings. There are 45 classes of the trademark, like as per the NICE classification. Suppose if you want to sell the chemicals, then you have to protect your trademark in class 1. If you are selling a cosmetic products, detergent powders, and the product which is used for the cleansing, that can be protected under class 3. All type of medicinal products, pharmaceutical products, and the dietary supplements, nutraceutical comes under into the class 5. All type of machine and the machine tools comes under into the class 7. Even every type of machines comes under into the class 7. Electronic components like electronic components comes under into the class 9. Like if you are selling some electronic components, then you have to protect your trademark in class 9. For medical devices, you have to protect your class in 10. For LED lights, you have to protect your trademarks in class 11. Suppose if some person having a one brand name is registered in class 1, suppose Rahul brand name is protected in class 1 for the chemicals. Oh, but if somebody want to protect their brand names Rahul in the class 7, then they can file. There is no objection, because these rights can be protected as per the class, except yet that your trademark is not well known in nature. We will discuss about the well known nature in our next. If the similar class is registered by the similar names in different class, then you can apply in the different classes also. For the garments, class 30 for the food items, class 35 for the trading, all type of education services, because most of the education coaching centers are here, education institutions are here. So you can protect your even institution name in the class 41. All type of institution name, university name, colleges name, even the institution, even music companies, entertainment also comes into the class 41. All type of restaurants comes into the class 43, and class 45 for the legal services. So these classes are defined as per the business which you are doing. Class 1 to 34 is for the product in which you are providing the products, and class 35 to 45 for the services in which you are providing the services like courier services, education services, restaurant services, legal services, and the social services. These are comes into the class 35 to 45, and 31 to 34 is for the product in which you are supplying the products. I hope you have seen the many question notice in the newspaper that please don't use our brand name. This is our identity, and this is protected by our as per the trademark registered. And we are well known in the market, and people identify our brand names as a niche. So these people just awareing the people about their brand names. So branding is helping by the trademark protection. So very important to understand what the role of the branding with the help of the protection of the registration. Suppose if you are going to market and somebody can offer this type of bottles without label, maybe you can't purchase without label the bottles. But similarly, one label is there given there, then immediately you can think this product is belongs to the distillery. So label is just, but the question is right, can trademark is protect the quality of the goods? No. Trademark does not represent the quality of the goods, it only protects the branding of the goods. Suppose if label is there, it doesn't mean that the quality of the product is also good. It can protect only the branding of the goods. So if label is not there, then the question is arise about the quality. But trademark creating a quality as well the goodwill in the customer of the market, that it protects lead to the that company, and that company has a goodwill in the market. So this is interconnected to each other. It takes a time to develop in the market to create a branding of the customer, like distillery. If some spelling is there, the people confuse which one is original. But most of the time, people think that it is a counterfeit goods related to the similar goods. But this is a look like a similar to each other, and this comes under into the trademark infringements. Distillery has their own value reputation, and distillery has a characteristics which is defined, and it took a lot of time to develop branding in their markets. Identify the symbol. I hope everybody knows that this is a symbol of Nike. But people maybe consider as this is a symbol of a tick mark. But The case of the Nike is very important to understand because it is popularity is considered as a well-known trademark because anybody knows that this is a symbol of the Nike, and these symbols can be identified without the word mark also because there is no need to mention Nike in below the marks because people identify by the only the symbol. So this is the identification. This is the benefit of the trademark protection. So what is the function of the trademarks? Allows companies to differentiate their products from one person to another person. This is the important function of the trademark. It ensures consumer can distinguish products and ultimately help the branding loyalty in the markets. So trademark plays a good important tools for the marketing and source of revenue through licensing. You can license your trademark to many persons that you can use our brand name. Like in the case of restaurant, you have seen there's many people using the same logo and the same name. They people license use their brand name for their ventures. Like in the case of school also, in the case of colleges also, many schools are distribute their brand name on the basis of the licensing. You can use our logo and our branding for their commercial purposes. This is the crucial component of the franchising agreement because when you are signing a franchising agreement with some educational institution, then you have to mention all the clause of the trademark acts that you can't disobey our registration and you can't use the trademark after the expiry of this agreement. So you have to mention all these things. May be useful for obtaining a finance also, a valuable business assets because people can identify by their brand names. Trademark protection is the exclusive right prevents other from marketing products under using the same or the confusing similar marks. Like I have already discussed Bisleri, Bisleri, Bisleri. These all are the confusing marks. The people can get confused by the similar brand name. So be careful when you are choosing a brand name. This you have to read the spelling and the identification of the products. It promotes the customer loyalty, reputations, image of the companies also. It provides courage in relevant market where business operates. Registered marks may be licensed or franchising to the other companies. So this is the scopes of the trademark protection. You will get a exclusive rights that nobody can use your trademark without the protection. If something good, then it is the case of the trademark infringement also. You can prevent others from using identical or similar trademarks also. So there are different types of the trademark. First one is the trademark in which you distinguish the goods from one person to another person. Like you are providing the products to the market, that is called the trademarks. And there is another mark that is called as service marks. I hope you have seen the first slides. There is a mention is a TM, SM, and R. So there are three symbols: TM, SM, and R. TM is used for the trademark. When we are applying the trademark, that is used as a trademark. It is not necessary you can write TM after the filing. You can use as a without the filing also TM. And R, after the complete procedure of the trademark registration, you will get a registered trademark certificate, and you can write a R. SM is for the service marks, like in which you are providing the services to the customer, like education services, restaurant services. These all are the services, courier services, to distinguish the services from one person to another person's. Collective marks apply by the group of association, like members of the association, like All India Management Association. These called collective marks. Is CM marks. These all are the collective marks, means applied by the member of the association. Certification mark like ISI, ISO, wool mark, egg mark. Certification marks identify the characteristics of the goods, means these represent the quality of the goods, means you have to follow the particulars, all the standards of the goods, then you will get a ISI mark, ISO mark, wool marks. Means you have to follow that criteria to get these marks. You have to follow these rules, and then you will get a certification mark. Certification marks is also the part of the trademark. You will get a certification marks also provided by the group of the association or the companies who follow this type of certifications. Well-known marks like Mercedes, Lions, Godrej, Tata, which having a good reputation in the market and the stronger protection in the market. Then people can identify by the images that even I have asked this question to you. Suppose if one brand name is Rahul is registered in class 1 and you are applying in class 7 for the Rahul brand. But if it is a well-known marks, then your trademark will not get registered in the all the marks. So be careful when you are selecting a trademarks. So these are the trademarks which we are using 6 a.m. to 10 p.m. All are the registered trademarks. In the morning, we can see our phone or watch for the time, and that is protected as a trademark registration like reasons. And after that, we go for the daily routines. We can use toothpaste, coffee, Nescafe, Dejmel, and we can use soap, we can use champs, that is also protected as a trademark registration. And after that, we can moving to the schools, colleges, or the somewhere, then we can use the vehicle brand name is also registered. We can use laptops and the computer, it is also protected as a trademark. So trademark is playing a very important role in our daily routines. So these all are the registered trademarks and having a very good identity in the markets. Which one is original? I think everybody knows that the people think like that Domino's is the original, but Domino's is also having branches in the market. So people may get confused, but it is not necessary that the product is somehow look like similar to each other, but they will get a registration if they get similar to each other and having a distinguishedness in the markets. Honda and Hyundai. If you can convert Honda into italic form, it look like somehow is a Hyundai. But both marks having a goodwill in the market, then people can identify even the product is somehow is similar to each other, but they will get registered because they have a goodwill in the market and having a identity in the markets. Good sale in the market. Now this is very important, especially because most of the time in the and the cosmetic products people get confused. One of the famous product is the Fair and Lovely, and another one is the Fair for and Love, and third one is the Fair My Love. Obviously, when you are selling a fairness claim, then you are using a word fair. When you are using a fair, like suppose if you are selling a pharmaceutical product, you are using a word pharmaceutical, and if you are selling a word surgical product, then you can add surgical, healthcare, and restaurant, hotel. So these all are the descriptive words and the generic words, and these words may be used, but maybe these both brand names are similar, Fair and Lovely and For and Love. But Fair My Love is a totally a distinguished word. Maybe it is its hallmark is entirely different from the Fair and Lovely. So these people maybe don't even the SSC is also mentioned there. So it is a distinguishedness. Their brand name is entirely different from the Fair and Lovely. Sometimes people are using artistic work. Maybe the label is similar, but the spelling is different. So this is also the example of the counterfeit goods. Dettol, Devtol, Purewell. So phonetically brand names also are not allowed. Suppose if you are selling a brand name which is a phonetically similar to each other, like OK and Ole. One alphabet is different, K and A. The shape of the good is similar, and the font style is also similar. So this is the direct example of the trademark infringement product of fruity and fruity. The defendant said this is a fruit juice and we are selling a fruit juice. In this product, this is a fruit in and this is a fruity. Maybe the both product is phonetically not similar to each other, fruity and fruitin, but the label of the good is similar. Shape of the good is also similar. Means you want to confuse the customer that this product is belongs to the fruity. So this is also the example of the trademark infringement. Distillery and the below. The shape of the label is also similar. The designing, spelling is different. The font style is also similar. If you can see, this is another example. But be careful in the case of the trademark when you are choosing the trademarks. Suppose you are taking a medicine, a Metzol 200, and doctor is recommending it for you. It's Rapunzel 200. But next time, if you are chasing the some chemist and maybe you are purchasing a medicine Metzol on the basis of the brand name, Metzol, and Metzol. All the brand names having a similar spelling or the phonetically similar to each other. Suppose if you are taking a Ismaprozol on the basis of on the behalf of Vitrajpol, maybe it is used for the gastric preparation. But if you are taking a daily albendazole on the place of Vitrajpol, so maybe it's a life-threatening also. You are taking a wrong medications. So trademark plays a very important role, especially in the case of the pharmaceutical science also. Because if your brand name, if you are not taking a right medication of the confusion of the brand name, so sometimes it's a life-threatening also. So be careful when you are choosing a medicine, you have to read the chemical name also. Because chemical name is identified by the important for the patients, not the brand name in this case. Sometimes people are using a chasing the name by adding some new words like new, blue line, Vaseline, blue star Valvoline. So this is the way to get a trademark registration, but these are not allowed. This company are very are aware about to protect their brand names. This is the best global brand names of 2024. Apple is the number one position and having a $488 billion business. The branding value of the brand names of Apple, and followed by Microsoft, Amazon, Google, Samsung, Toyota, Coca-Cola, Mercedes, McDonald's, BMW. So this every year they can identify by the goodwill of their brandings in the market and by the reputation in the market, and the sale value also matters. Most valuable brands in India in 2024 by brand values in billion US dollars is Tata Consulting Services, HDFC Banks, Airtel, Infosys, State Bank of India, ICICI means mostly banking systems are there, and the consultancy services is providing the identity in the market on the basis of the branding. Copyright trade dress protection. So this is very interesting because trademark is not only the protection of the name, it is also protection the trade dress, also the identity of the label also you can protect with the help of the trademark protection. Parle-G. It is just an old product around 35 years old. People can identify the label of the products. So this is the identification of the products. Move. Suppose one medicine is coming in the market, MOOV, move, useful for the pear leaf. If somebody can sell a medicine by the spelling name of MOVE for the diabetic patients. So people get confused that that is the move MOVE or MOOOV. So phonetically brand name, this is the reason phonetically brand name is not allowed, because they may confuse the customer by the spelling of the or the phonetically pronounced the brand name. So these type of brand names are also not allowed by the trademark registry. This is the administrative setups of the trademark registry. This is run by a Department of Industrial Policy, Promotion, and Ministry of Commerce and Industry, and followed by the Controller General of Patent Design and Trademark. The trademark registry. We have 5 offices in Mumbai, Delhi, Kolkata, Chennai, and Ahmedabad. These 5 offices is divided according to the jurisdictions. Suppose if you are filing a trademark from Maharashtra, Madhya Pradesh, and Goa, and your application is forwarded to Mumbai, then Gujarat, Rajasthan, for you have to file the trademark registry in Ahmedabad, Chennai, Andhra Pradesh, Kerala, Tamil Nadu, Karnataka. This is divided according to jurisdictions. Himachal Pradesh, Haryana, Punjab, and Himachal, you can through the trademark registry. How to select a trademark? So this is the important questions, because you want to start become an entrepreneur. The first question is rise, how to select a trademark? Because most of the people come to me and say, sir, what is the criteria? What is the basic criteria to select a trademark? Most of the time people said that ki Pandit ji ne ye naam bataya tha. The religious names. Sometimes religious name may get refused by the trademark registry because these names are not allowed because of these religious natures. So selection of the trademark is very important. Suppose your word must be easy to spell, easy to remember, like Sony, Tata, Bata, Reliance. These are the easy word to spell. You may also point some words like which is having a no meaning in the dictionary, like Kodak and Dalda. Kodak and Dalda has no meaning in the dictionary, but people can identify Dalda is related to the some product which is manufactured by the milk, and Kodak is related to the photographs. Means people can identify the spelling, but it has no meaning in the dictionary. So point word are easy to get registration in the trademark registry. So this is better way to get the trademark. You must point your name, and maybe some adding 5 alphabets and make a brand name is popular in it. But mark should not be according to a geographical name like Ludhiana Steels, Chandigarh Salt, Delhi Pharmaceutical. Avoid such type of name which is related to some geographical name. Most of the time people get a name by the geographical name, but they will get a rights on the label, the representation of the mark, like logo of the mark, but they will not get a monopoly rights of the words like Ludhiana, Chandigarh. They will not get a monopoly rights of the words which is related to the religions, geographical name. We will not get a station name also for any religious names like Om, Ekonkar. This type of brand names are not allowed by the trademark registry. Avoid word which describe the quality of the goods, like best, perfect, super, premium, supreme. These type of which represent the quality of the goods. A milk, and you are choosing a brand name pure milk. Obviously, milk is pure. So these type of word which describe the quality of the goods. This type, like if you are selling a furniture like perfect furniture, yeah, perfect paintings, perfect glasses. So these type of words may be a descriptive in nature and describe the quality. As you've seen, that Dalda has no meaning in the dictionary. So how you can protect a trademark? You can protect in India. You have to file your application in India through the trademark registry office. Or if you want to file a trademark outside the India, then you can submit by 2 ways. Either you can directly apply through the regional routes of that country, or you can submit by the international routes. International routes, you can submit your application by the Madrid Protocol. Madrid Protocol now has a 115 members countries, 131 countries and 115 members. So this is the best way to file the trademark application through the Madrid Protocol if you are running your business in India. So Madrid Protocol, India has joined the Madrid Protocol in 8 July 2013. And what is the benefit of the Madrid Protocol? It allows the Indian trademark owners to file a trademark application internationally by a single application. By single application, you will get rights in multiple countries. But the certification granted by the particular that countries. Madrid Protocol just help you to submit the application in multiple countries. And this is run by with the help of the World Intellectual Property Organization. The Madrid system just streamlines the process and reduces the cost compared to filing the separate application in each country. Suppose if you are filing an application in China and USA and other countries, then you have to submit a separate application in each country, and you have to find out the way to submit the fees in each country. But with the help of Madrid protocols, you have to submit the single application, and you have to submit the payment mode in the single way to the Madrid protocols. What is the benefits of the Madrid systems? It just helps us simplify trademark registration process, and Indian business can now register their trademarks in multiple countries through a single application, making the process more cost-effective and less time-consuming. It is a centralized management system which helps the trademark applications, renewals, and other process by the help of the Madrid system. It increases the global reach also. If your trademark is filed for the Madrid protocol, anybody can search out for your trademark application is available on the Indian Madrid database also. This is also beneficial for the micro, small, and the medium enterprises, particularly for the medium side that may lack the resources to file a separate trademark application in multiple countries. And Madrid protocols also align the trademark system with international standards, protecting the international harmonization. So what is the process of the trademark registration? Initially, you have to search your trademark. Either it is not a descriptive in nature and the phonetical in nature. We will show you some trademark search engine also, where you can find out how you can search your trademark applications. You can search your trademark application. Even nowadays, trademark registry has launching an AI method to find out the trademark registration process. You just, before searching of your trademark application, you ensure that you are not copying anyone else's brand name or look like a similar to any other brand names. Trademark searching by, you can submit your trademark application by online mode and by offline mode also. For online mode, you will get a 10% rebate for the filing of the trademark application process. You have a class 2 digital, class 2 or class 3 digital signature, and you have to register your portal through online mode, and you can submit your trademark application through online portal. Then after the filing of the application, either your trademark will be accepted or objected. It depends on your trademark. Suppose if your brand name is Rahul, R-A-H-U-L, and obviously if some person is selling the goods by the name of R-A-H-U-L, Rahul. So this name is cited and this name is phonetically. So maybe your trademark is objected because the similar brand names which is phonetically similar is already available in the trademark registry in the same class. So this is the reason of the objection. If your trademark is not accepted, then your trademark will be published in the trademark journal. And trademark journals allows 4 months to the other parties. If somebody has some objection for the registration of the trademark, then they will file the opposition to the trademark registry. Then after the filing of the trademark opposition, the applicant has submitted the counter statement within the stipulated time within the 2 months of the submission of the trademark opposition. Then if there is no opposition filed by any other party, then your trademark will be registered. So this is the whole procedure. And then if your trademark is objected by the trademark registry, then you have to submit the reply to the trademark registry that your trademark is entirely different from the site trademark. Then if the examiner is satisfied by your trademark, then it will be accepted or it may be refused. It depends on your trademark, that how you can submit your application. So this is the procedure of the trademark registration process. So you can also file your trademark file. It is not necessary you can hire any advocate or the agent. Any entrepreneurs can also file the trademark procedure. This is the copy of the trademark certificate. After the complete procedure, you will get a certificate like this that your trademark is registered. You will get a trademark registration for the 10 years from the date of the filing, not from the date of the registration. Suppose if you are filing a trademark on 14th March 2024, then you will get a right for the 10 years, 14th March 2034, not from the grants. So like patent. In the case of the patent, you will get rights from the date of the filing. This is the website of the ipindia.gov.in. You can click on the trademark options. Then you have to click on the related leads. Then you have to click on the public search. Trademark related leads and the public search. This is the website ipindia.gov.in. Then you will get a search engine, public search engine, where anybody can search their brand names. You can search by the start with the brand names, and you will get it. You have to enter in the, like you have entered the brand name Elna, and the class is the 5. Class 5 is for the medicinal preparation, medicinal, and for the pharmaceutical, nutraceutical. And you have to enter the captcha. Then after that, you will get a search report like this. Elna Nutraceuticals, Elna Biotech. All the brand names are first and second are the first is registered, second is the accepted and advertised, and third one is the objective. First one is the registered means this process is trademark registered, and second one is accepted because cited mark is belong to the first person. Both the companies are linked to the single person, so these brand names reason this is the similar brand name is accepted. Third one is objected because maybe they have given the someday different address. So this is the reason of the objections. You can see many brand names which is starting with the Alna. This is the search engine. Now, what is the comparison of the brand name? So one is the brand name is NextVit and another brand name is the NextVita. And only the one difference is the Vita and the Vita. Maybe this brand name is the phenotypically similar. So this is the reason of the objections. So when you are choosing a brand name, then your brand name is distinguished from the cited mark. Otherwise, it will be objected by the trademark registry. And this is the example of the trademark search report of the discipline. Now you can see the filing of the trademark application of discipline 3rd September 1946. Before independence. Now you can see the people are awaiting for the protection of their brand name from last decades. Discipline X filed in 17th May 1971. Discipline CV 1989. Class 10 for the surgical items. Like now you can see the many people are using a word medical devices. Medical devices is a descriptive words, but OnMed is a distinguished word. OnMed oncology. SM is a distinguished word because people can use the descriptive words at the healthcare, pharmaceutical, medical devices, and surgical. These are all are the descriptive words may be used, but first word must be a distinguished in nature. Hospital is class 44. Anybody can use hospital words as because hospital is a descriptive words. Form and fees. For the filing of the trademark application, you can submit your trademark application by two way. You can submit by online mode. You can submit by offline mode also. For the online filing, you have to submit rupees 4,500 and you have to submit the form TMA. There are total 8 forms and this is very easy trademark application. TMA you have to submit for the initial filing of the application. It is a single page application where you have to enter the name of the applicant, address of the applicant, brand name. If any images are there or logo is there, you have to enter the logo in the JPG format in 8 by 8 centimeter shapes of the logo. Then you have to enter the class, in which class you want to a protection. Like suppose if you want to protect in class 1, then you have to protect class 1 for the chemicals, chemical name class 1. You can select the classes as per the NICE classification and the details of the classes are given on the website also. Then if you are submitting an application offline mode by hand also as a trademark history, then you have to pay fees 5,000. And this is fees for the individual, startup and the small enterprises. But for the rest of the other people who are the large entity, for the online fees is 9,000 and for the offline fees is rupees 10,000. Then I have already discussed the procedure of the trademark registration. If somebody can oppose our trademark, then you have to submit the counter statement with the help of TMO. Even the opposition filing is with the help of the TMO. Then for the online filing, you have to submit the fees rupees 2,700, and for the offline, you have to submit the fees 3,000. After the completion of the 10 year, you have to submit the renewal fees. And what is the renewal fees? There is no differentiation between the SMEs, SME and the large enterprises for the renewal. For both cases, the fees is renewal is same. For this online filing, if you are submitting the fees for the online filing, then you have to submit by the form TMR. R means renewal, A means the application, and O is the opposition. This is very simple way to identify the form for the submitting of the application. And from if you are submitting your application by offline mode, then you have to submit the fees rupees 10,000 for the offline filing. So this is all about the trademark protection. And if you are not submitting the fees for the after 10 years on the time, then you will get a times for the you can submit the application after 1 year of the expiry of the trademark registration. For the next month after the expiry of the trademark, like suppose if your trademark is expire on 24th April 2025, then you can submit the late fees rupees 4,500 for the online filing until 6 months, 24th October 2025, you have to submit rupees 4,500 and offline fee rupees 5,000. And for the next 6 years, after the expiry of the 6 years, you have to submit the renewal fees 9,000. So you can mark your date, then your trademark expire after 10 years. Because most of the time I have seen the entrepreneurs forget their renewal of the trademark. Even they can forget after the expiry of the 1 year also. Then they have to file the fresh application. For the fresh application, you have to follow all the procedure of to get the registration certificate. Like you don't get a registration certificate like in the single shot, then you have to examination report will come, objection report. So you can just mark your date that your trademark get you expire on that date. Now is the geographical indications. Geographical indication is basically intact in India with the help of the Geographical Indication Acts came in force with September 2003. Geographical indications is the indication to identify the agricultural goods, natural goods, and the manufactured goods originating from a particular territory in the India. It should have a special characters and the quality of the goods based upon the climatic or the production characteristics unique to the particular regions. And the geographical indication is not granted to any single region. It is granted to the group of the cluster of the association or persons which is located in the particular territory. And this is granted only to the manufacturers, not to the traders. Those people are manufacturers in the particular regions from last few years, they will get a trademark geographical registration. And this is a collective rights, as opposed to, this is not a private right, this is a collective rights. And any association of persons, producer, organization established under the some law can apply for the trademark protection and geographical protection. It identifies the product as originating in a country or the regions. The government of India is doing a very good work in the protection of the geographic indication. Last few years, many GIs are registered in many regions because GIs represent the quality, reputation, and the characteristics of the particular regions of the that regions. So it is an identification. It particular identify the identity of particular regions. It may be a natural goods, agriculture goods, and the manufactured goods. Like trademark registration, you will get a geographical indication for the 10 years. You can renew for unlimited time. You can renew for after every 10 years. And geographical indication, trademark you may be assigned, transmitted to any another person, but geographical indication cannot be assigned or transmitted to another. This is the example of the geographical indications of the India. Basmati rice, Mysore silk, Mysore sandalwood, Mysore jasmine, Darjeeling tea, Tirupati laddu. So this is the geographical indication which is registered in the India. And some of the famous world Canadian whiskey, tequila, champion. This is an example of the geographical indication which is registered in the worldwide. So difference between the geographical indication and the trademarks. Trademark is granted to a single person, any individual, any startup, any MSMEs, any single entity. But geographical indication is granted to the company, some association, organizations, not to any individuals. So GI is closely related to a trademark, but they having a different identity. Both indicated product origin. One is the origin from one single entity, and one origin to the particular community, to the particular society. So this is the difference between the trademarks and the geographical indication. Most of the time people get confused how we can distinguish with the GI or the trademark. GI is given to the society, to the community, and trademark is related to the single entity. Thank you so much. If you have any questions related to the trademark, you are free to ask me.